I'd like to introduce Michael Elsken. Michael is a staff attorney with Disability Rights Nebraska. Before starting with Disability Rights Nebraska, he was in private practice and focused his practice in the areas of bankruptcy, civil, criminal, and juvenile law. Since joining Disability Rights Nebraska, Mr. Elsken has engaged in a broad range of protection and advocacy activities for the agency on behalf of individuals with disabilities in the state of Nebraska, including litigating issues for individuals with disabilities, presenting at educational and training programs for individuals with disabilities, and for entities who supply services for individuals with disabilities, monitoring activities designed to protect the interests of individuals with disabilities, and training on a broad range of disability rights and cultural competency issues. Please welcome Michael.
Good afternoon. I have a tendency to run long, so I have an alarm on my cell phone here. So when it goes off, I shut up. If there are any questions or anything that come up, I'm around. I'll be glad to answer any questions that I don't reach to. Disability Rights Nebraska is what they call the Protection and Advocacy Agency for individuals with disabilities. Every state has a P&A. Every U.S. territory has a P&A. There's even a P&A that's specific for Navajo and Hopi tribes. They sort of acquired the name the Native American P&A, but they only deal with those two tribes. But we do a broad range of disability-related activities. Animals for individuals with disabilities, they're important. And they're important because they serve a function. They are a tool for individuals with disabilities. Everyone uses tools, whether that be a knife and fork, or a pair of glasses, or a hammer, or a chisel. Individuals with disabilities use animals as tools on a broad range of things. And you have to understand, when you're dealing with individuals with disabilities, because they are a tool, they're not special, right? They are a device that is designed to allow them to overcome some aspect of their disability. I always talk about tools of this sort being a liberating device. A person is not confined to a wheelchair. What's confining to the wheelchair is the MS, or what's confining is the MS or the spinal injury because of the DWI accident they had, or an IED. That wheelchair is a liberating device. Animals can be a liberating device for individuals with disabilities. And just like any other tool, how it functions somewhat depends on where it's functioning. And how it functions and where it functions mesh together. So when you talk about animals and individuals with disabilities using it as an animal as a tool, the first thing that you really have to overcome is we're not talking about animals as pets, right? Animals for individuals with disabilities, when they're being used as a tool, it's not just a pet. It serves a function for the individual. And that's relevant because there are a lot of restrictions that exist for pets. You have to have pet deposits. You may have a no pet policy for certain locations. A lot of restaurants are not open to pets, but they are open to service animals, right? So when you start talking about animals and individuals with disabilities, when the concern is relevant in terms of the law, depends on where you're talking about. There are four major divisions in terms of animals and their use by individuals with disabilities. First one is the Americans with Disabilities Act. A lot of people think they know all about the Americans with Disabilities Act. I can almost guarantee you that with respect to animals, a lot of people don't understand what the ADA is talking about. I know this because we hear about it all the time. The second major statute that applies, and bear in mind, some of these statutes, the Disabilities Act and the Fair Housing Act, have Nebraska parallels. There is a Nebraska parallel to the ADA. There is a Nebraska parallel to the Fair Housing Act, which is actually reaches to circumstances that don't apply to the ADA. There's an ADA requirement of a certain number of rental units before a landlord may be, or not ADA, the Fair Housing Act. There are a certain number of rental units that a landlord may be responsible for before the Fair Housing Act applies, fewer numbers under the state statute. Obviously, housing, the Fair Housing Act applies to housing, and we're not talking about individuals' homes, we're talking about rental facilities. There's the Air Carrier Access Act. That statute exists largely because air carriers were initially exempted from the implications of the Americans with Disabilities Act. That's the reason why you don't have to have aisles that can fit wheelchairs down your airplane. They're exempted from the Americans with Disabilities Act. So they came up with a statute that applies for individuals with disabilities in the aircraft setting. And there's an animal provision that deals with that interface for the individuals with disabilities in the aircraft setting. And the fourth statute, and you don't see a lot of this, is Section 504 of the Rehab Act. That is a provision that applies to any federally funded service or activity, regardless of whether or not it's considered a private or public location. So private clubs may not be subject to the Americans with Disabilities Act, but if they receive federally funded, if they receive federal funds for their private club, they may be subject to 504. All of those statutes can reach to the aspects of animals and individuals with disabilities who utilize animals. Now there's two major differences in terms of animals. There's the service animal and there's the emotional support animal, right? Service animals are specifically defined. They are animals that the Justice Department has issued guidance in terms of identifying what is an appropriate service animal. And some of that is historical in context. After the passage of ADA, there were a lot of animals that were treated as service animals that are not considered service animals now. The most classic example is you saw a lot of people who had capuchin monkeys that would help them with their activities of daily living, whether that be reaching down and getting stuff off the floor, helping them get pots and pans from the cabinet, whatever. And because there was a lot of pushback and concern by a lot of entities as to where do we draw the line about what constitutes a service animal and what isn't. The Justice Department has issued some guidance in regard to service animal, and that term really applies under all four of the statutes, the ADA, the Fair Housing Act, and the Airline Act. And it's deemed to apply under 504, even though 504 doesn't specifically talk about animals themselves. So what constitutes a service animal under the ADA? When the ADA was passed, most people thought about service animals as seeing eye dogs. That was the general context that most people thought about. But because individuals with disabilities are not limited to being visually impaired, and because service animals can do a lot of things for people that went beyond that context, the idea of what constituted a service animal has changed. Generally speaking, individuals who use service animals may not have a readily apparent disability. It's not like you're blind, right? Individuals who have disabilities, a lot of individuals who have disabilities who utilize service animals, you would never know that they have a disability. The classic example is the service animal that alerts for epileptic episodes. 99% of the time, the person may have no apparent disability. Have a disability, but that service animal is available for them regardless of whether or not they're having an actual episode. Again, I talked a little bit about the fact that service animal, the concept expanded to include animals that were not traditionally considered service animals. The capuchin monkeys, there was a huge market specifically training capuchin monkeys to do work in this regard. But there was enough pushback that the ADA, the Department of Justice, decided to define what constitutes a service animal under the ADA. Now, the Justice Department guidance is not absolute, right? The fact is, the courts have never ruled whether or not the Justice Department's limitation as to what constitutes a service animal is consistent with the actual ADA statute. Because the ADA statute doesn't define what a service animal is, right? It just says that the service, an individual with a disability may use a service animal. But the Department of Justice limited service animals for their purposes, and until courts tell us otherwise, that's what's going to be considered appropriate to dogs and small ponies. And they're not breed specific. So you can have a Yorkie as a service animal and still meet the criteria of the ADA. I have literally seen an individual with a Yorkie service animal, had a vest and everything. And I'll go into whether or not you need vests, but it doesn't mean that the Yorkie's something that the person leans on for balance purposes or anything like that, but as long as they met the criteria in terms of the ADA for the Justice Department, any dog and certain small ponies can constitute service animals. There's a difference between a service animal and an emotional support animal. The ADA doesn't talk about and does not specifically recognize protection for service animals or for emotional support animals, even if it's a dog or pony. But under the Fair Housing Act and the Airline Act, emotional support animals are protected. Emotional support animals are not limited to dogs or ponies. A cat can constitute an emotional support animal. Wouldn't be protected under the ADA, but it would be protected under an emotional support animal. That's important in a lot of circumstances, because if you are looking at restrictions in terms of an animal, just deem it as a pet as opposed to an emotional support animal, there are a lot of restrictions that exist. Now, regardless of what law applies, there are certain things that need to be borne in mind. Neither service animal nor emotional support animals require any advertised online certificate for your service animal. It's not required. There is not requirement that a person show a card says my animal is a service animal. Doesn't have to have a vest. There's a rather good book by the name Until Tuesday about a gentleman who received a service animal after being injured in an explosive device while serving in the military. He had a dog named Tuesday. Tuesday, he was trying to get on the bus with Tuesday. Tuesday had a harness but no vest, no identification. Bus driver refused to let him on. That's actually a violation of the Americans with Disabilities Act. He knew it, but he was not in a position to argue with the bus driver about the fact that you don't have to have a vest, you don't have to have a card, you don't have to have a certification. All right? You can ask a couple of questions, both with service animals and with emotional support animals. You have to be able to identify what the service animal does for you, right? So if a person wants to know what your service animal does for you, that's a legitimate question. So person shows up with that Yorkie in the store, the store owner can say, well, I see you've got a service animal. What does that service animal do for you? That's a legitimate question, but you cannot go into great detail. You cannot demand detailed explanations about what the service animal does for you. You don't have to answer 60 questions, but you do have to be able to answer, what does this service animal do for you? It's not a dog and pony show. You don't have to show how the service animal does, even though the service animal is restricted to dogs and ponies. It is not a dog and pony show. You don't have to show what the animal does. You just have to describe what the animal does. Emotional support animals are different because emotional support animals may serve their function simply by being present. Classic example is a child who may have a panic attack disorder or who may have depression, who has a service animal, a cat or a chicken. Quite literally, our office is dealing with a litigation involving a city that tried to demand that this mom of 2 children with autism get rid of some chickens that they have. The chickens are the emotional support animal for these 2 children with autism. They tried to bring a lawsuit against them. They got countersued right away about these are emotional support animals. This was a residence. They were trying to say you can't have chickens. They don't even constitute pets. They're livestock. And that one we're still dealing with, but we're likely to get settled simply because we were able to identify. Children's doctor said, these children have this disability and these chickens emotional support function for these children. They're entitled to keep them at the residence.
Can you make that a condition of rental, that there be some showing by a doctor?
You can request, if a person says, I have an emotional support animal, you can request information from the doctor showing the disability, right? And you can request that there be a demonstration of how that disability relates to the emotional support animal, right? So if the child has panic attack disorders or clinical depression, and you'd be surprised the number of people that have some sort of hidden disability. If you're dealing with a family who one member has a significant disability or illness, 85% of all the other family members are likely to have a disability in terms of anxiety or depression or some other related circumstance. My wife has had MS for 26 years. Every single one of our family at some point or another ended up having some clinical concerns because of the stress generated by my wife's condition. But as a landlord, you can request the information about what the nature of the disability is and how this animal, whatever animal it may be, helps address that disability.
So hypothetical, so the person comes to rent and they have a baby pig.
Mm-hmm.
And you could ask the question, if the the doctor says,
Support animal.
but you could not ask if the pig had been trained.
No. Right? Because emotional support animals do not require any specific training.
Is it a potential tenant under any obligation to let a landlord know in advance?
Well, most landlords have restrictions or pet deposit requirements, right? The nice thing about emotional support status or service animal status is they're not pets. So if a person needs an emotional support animal or utilizes an emotional support animal or utilizes a service animal, and the landlord says, well, we're going to take that 25% extra deposit because that's a pet, that usually triggers the discussion, right? Or if the landlord gets a notice, you have an unauthorized animal in your residence, you have 14 days to get rid of the animal or vacate the premises. That's normally when that type of situation arises where the individual who's using the service animal or emotional support animal gets the required information. There's not an affirmative duty beforehand, but it almost always happens. Usually, in terms of when our office sees the problem arises when the person either acquires the animal and moves the animal in, whether it be a service animal or an emotional support animal, and someone sees it. You know, the neighbor who rents the apartment likes cats, would like to have one themselves, but doesn't need an emotional support animal. The person moves in, gets them a cat. That cat serves an emotional support animal purpose. The neighbor gets pissed off because they can't have a pet because there's no cats allowed in this apartment complex. That's usually the type of situation where that arises. You have the right to, as the landlord, obtain the medical verification that the person has a disability and that the animal provides assistance. Doctor doesn't have to answer 20 questions either. And if you're asking about an individual who has an obvious disability, that in and of itself is inappropriate. You shouldn't be asking if it's obvious that the person has the disability. The only real question is it a service animal or an emotional support animal? If it's a service animal, what does that animal do for you specifically in terms of meeting the needs under the ADA?
You can ask in that case for training.
Well, there's no requirement for outside training. You can self-train your own dog, but you have to be able to say, all right, this is what it does for me. Now, and I know an attorney in Lincoln who has self-trained his own dog. He used to play football. He's got huge knee problems, balance issues, whatever. He self-trained his own dog. And the last time he went to Mayo Clinic and brought the dog in with him, the doctors were like, that is the best trained dog we've ever seen in our lives. He did it himself. As long as the person can articulate what the animal does for them, that's sufficient to answer the inquiry. You can't ask for specifics about training. You can't ask for a graduation card from whatever entity they may or may not have gotten the animal from. A lot of places, a lot of individuals who have service animals, they love to tell you where their animal is from, whether it be from KSB down in Kansas or ECAD, which is out of New York, or there are places all over the U.S., domestic pops here in Nebraska. A lot of places, a lot of individuals who get animals like to say where they're from because they're proud to have that service animal. Now, the emotional support animal doesn't have to have specific training. You just have to be able to articulate what it does in terms of the emotional support. Yes?
So I don't want to say a boa constrictor or a more dangerous snake or a gerbil or something different. Yeah, a peacock. The idea of noise and smell.
All right. There are requirements in terms of both service animals and emotional support animals. You have to be able to control the animal. A lot of people are concerned about, oh, is that dog going to bite me? Quite literally, that's one of the things that a lot of places say, we don't want to have that German Shepherd or Pit Bull who happens to be the service animal because I'm afraid he'll bite me. You have to maintain control of the animal. If you don't maintain control of the animal, you can be forced to get rid of the animal because you're not exercising that control. The mere fact that an animal is different than you or I might like as an emotional support animal, that's not the determining factor. I know guys that have pet boa constrictors. They wrap them around their neck and they say, oh, I love that hug they give me. It's like, all right, that would be too much for me. That could qualify as an emotional support animal for that individual, right? But if that boa constrictor gets out of the apartment, gets somewhere else, you're not exercising control over that animal. Same is true with the gerbil. Noise has to be excessive. The mere fact that a dog may bark periodically, that is not going to be sufficient. But if it barks incessantly,
I would put that into the context of the emotional support.
yeah,
I can understand.
you know, those kinds of things, those are really fact-based as opposed to just what the law says. You have to exercise the control over the animal. And my judgment is not the judgment of the individual with the disability. The example I use is that huge Maine Coon in an efficiency apartment. I wouldn't necessarily want to have a huge Maine Coon in my efficiency apartment, but that's not my call. It's the call of the individual with a disability. Emotional support animals are not protected everywhere, right? Emotional support animals are not within the context of the Americans with Disabilities Act. So you may be able to take your service animal to the hospital or into the restaurant, but you won't be able to necessarily bring your emotional support animal to that restaurant. Even if that emotional support animal is a dog. A lot of restaurants, if you have a dog, they'll ask if it's a service animal before they are obligated to let you in. And they can ask what that service animal does for the individual. Emotional support animals are protected under the Fair Housing Act and the Air Carrier Act. Now, The Air Carrier Act, they're still hammering out what constitutes reasonable restrictions in terms of the emotional support animal. And I imagine a lot of you saw the news article a few months ago about the emotional support peacock, right? That they wanted to bring onto the aircraft with them. And the company involved said, no, we're not going to do that. I don't know if anyone's brought any litigation on that. That's a gray area in terms of whether or not the aircraft requirements of the Aircraft Act would allow that as an emotional support animal. Fear cannot be the controlling factor. A lot of people are afraid of pit bulls. Pit bulls may lick you to death, but your fear of that pit bull doesn't mean that it can't be a service animal. Even though Delta Airlines, under the air carrier provisions, recently said, we're not going to allow pit bulls on our aircraft. I don't know if that's gone to litigation yet.
On the Air Carrier Act that you're talking about, would it be a violation of the sort of ADA if they required I don't want to call him the person at issue who wants to bring a support dog or support animal or a service animal to require them to purchase an extra seat?
There's some question as to that. A lot of aircraft, if you exceed certain weights, will require an extra seat. So if you combine the weight of the two, the person and the animal, they may articulate that that's appropriate. Yeah, you know, and that becomes a question of context. Again, the Air Carrier Act, the restrictions and requirements are still being hammered out because it's relatively new by comparison. The ADA has been around for 28 years. The Fair Housing Act is 22 years, something like that. The Air Carrier Act is less than 10 years into this process. The Irish Wolfhound, saying that you can't have an Irish Wolfhound, and I use that as an example because my son is deathly afraid of Irish Wolfhounds. That does not constitute a reasonable restriction. A person with a service animal or an emotional support animal. Emotional support animals really deal with rental properties, so the concern of the neighboring residents or people who might see the emotional support animal being taken out for purposes of doing what it needs to do. Most people, when they're talking about emotional support animals, it's their own apartment, or if it's the Aircraft Act, it's in the terminal or aircraft itself. College dormitory is considered a residence, you know, so it does apply there. Yeah, so wherever a residence, you have to think about the Fair Housing Act. Mm-hmm. Dog or a cat. Yeah. You know, and
all the other things that have to be done to care for that reptile / animal, that's not defined.
mm-hmm.
Comfort purposes. And the inconvenience and the discomfort to
but the fear of others cannot be controlling. If you're afraid of, those are fact issues. If you demonstrate that it's putting out a huge smell and it's being problematic, then there may be a requirement there. If it's constantly barking, certain animals are taught to bark to alert. So if a person is visually impaired, they may have a dog that barks when someone's knocking at the door. Danger can be a defense. Actual danger can be a defense for excluding a service animal or an emotional support animal. But the mere assertion of the danger, the smell, the noise, that is not enough to say you can't have the animal there. Entities can exclude an animal if allowing the presence would constitute a fundamental alteration. Not every alteration is fundamental. It has to go to the very core of the business being impacted by the presence of the animal. I'll tell you that hospitals used to assert that allowing a service dog into the hospital constituted a fundamental alteration. That's not going to fly. Animals are allowed in hospitals. There, literally, when I was working on this PowerPoint, there was a decision out of Massachusetts where a person was not allowed to have their service animal in the ambulance with them. That was a violation of the ADA because the service animal for that individual, one of the things that it did was allowed him to remain calmer. And when you took that away and you had him in the ambulance, that was a stressful situation to begin with, and it was magnified even worse because he didn't have his service animal with him. Saying that other people might want to have animals is not a fundamental alteration. If the other person has a disability, they may be able to get the animal. If it's a Fair Housing Act, they'd have to show the existence of the disability and how, the fact that addresses that emotional support animal addresses that disability. If it's a ADA question and it's a service animal, you have to be able to articulate what the service animal does for you. The person without the disability or has a disability that doesn't utilize a service animal, they can't just say, I want an animal because that person has it. They have to demonstrate the relationship. The other defense tends to be the undue burden. And not every burden is undue. And normally it's a situation where actual burden, financial burden, cannot be readily absorbed by the business. I have yet to see a business successfully assert that the financial burden of allowing a service animal on their premises was actual and real, no less that it created an undue burden, financial burden for them. How have health departments responded to that?
How have health departments responded to that issue in terms of bringing a service animal into a restaurant?
Into a restaurant? Generally speaking, health departments are more concerned about the circumstances of the business itself and not their patrons. If the patron brings the service animal into the restaurant, and the restaurant allows that, that's not a health code violation. Now, if the service animal was uncontrolled, they wouldn't function as a service animal, that could create a problem, but that's something that the restaurant could act to prevent. They could say, you have to take your out of control animal out of here. We're not going to allow that. Hospitals used to argue all the time that allowing a dog into their hospital was dangerous to the health of patients. They lost those. A lot occurred over and over again. You can't be supposition. You have to be able to demonstrate the actual negative impact. Hospitals quit fighting that issue. As a matter of fact, our office handled the situation where they were doing a tour of a new wing of the hospital in western Nebraska, and they refused to allow this woman who had a service animal, and the hospital actually knew the woman and knew of her disability. The staff member said, no, you can't have the animal in the hospital. So you can't do this tour. Our office wrote the hospital about this, and the executive director for the hospital wrote back immediately and said, we will make an arrangement for a tour for her at any time she wants to with her service animal, because they could not restrict that. The individual with the disability remains responsible for exercising control over the animal. There are times when that can even be having someone come and assist with that. Classic example is the 5-year-old who has a disability, who has a service animal, and the school says, no, we're not going to allow him because he can't take the dog out on his own at 5 years old to potty the dog when it needs to be pottied. The solution there is that the person is allowed to have someone other than themselves go out and take the animal to relieve itself. The individual with the disability can be required to show that the animal is properly vaccinated and licensed. I know the discussion earlier was about licensing and the fact that they would be considered contraband. Under the both the Fair Housing Act and the Americans with Disabilities Act, there can be a request that you show that the animal is licensed and vaccinated. So a lot of people who have service animals have a little card that shows the vaccinations for their service animal. Having the tag on the collar, that's usually sufficient for demonstrating licensing. Genuine failure to meet those obligations can be a basis for denying the presence of the animal. So, if your jurisdiction says you have to license that ferret and you don't license that ferret, that can be a reason for excluding the animal. Not all animals require licenses. You don't have to license a gerbil.
What about only inside of the city limits that has an ordinance banning
Well, if,
livestock?
Can you repeat that one?
sure. He wanted to know what about a pony that has inside a municipality that restricts on livestock. Ponies can be service animals. Ponies can be, they can be required to be licensed, but you can't say you can't have that animal because it's livestock. It's no more livestock than it is a pet. It is an emotional support animal or a service animal. There are a lot of resources for knowing what's going on in terms of what's applicable under the requisite statute. I'm just checking my time here. I'm getting close. The U.S. Department of Justice has issued ADA guidelines. Those guidelines apply to service animals. These are all online. You can access them anytime. Department of Housing and Urban Development has letters regarding both service animals and emotional support animals. They're very descriptive. Department of Transportation has information both on service animals and emotional support animals. Those are, because it's a relatively new statute, those are getting more and more detailed over time. Your question about service animals and residents and college settings, the U.S. Department of Education has even issued guidance specific to that question.
Well, we had the Kearney campus dormitory companion case that actually went to settlement.
Yeah.
Probably was precedent for many other cases now that are being filed against universities across.
Well, I don't know if it's necessarily precedent. I think the Department of Education actually took the position before the Kearney case went, but it's consistent with the general requirements under the Fair Housing Act. So a lot of what the U.S. Department of Education did in that situation was take the information from the Housing and Urban Development and put their own imprimatur on it. They've also addressed emotional support animals. There are some great resources. Every region has what they call an ADA center. Ours is the Midwest ADA Center. It's out of Kansas City. They're online. You can call them. They'll answer questions for hours because they're there to let people know. Regional Fair Housing Authority offices will do the same with respect to the Fair Housing Act. The regional office is here in Omaha. State Protection and Advocacy Agencies, Disability Rights Nebraska is the agency in this state. Every state there's an Iowa Disability Rights Office. There's one in Kansas. And this is stuff that we share information about. So this is not new. If you have a question that we can't give an answer to, we'll normally say, well, let me check with our listserv, because we have a listserv that handles all the protection and advocacy agencies. Usually within 48 hours, we can give an answer. Our office on our website, I didn't have it on my introduction, but it's www.disabilityrightsnebraska, all one word, .org. We have the website lists resources. If you click on the resources button, we have information sheets, what we call law and briefs, specifically on emotional support animals and service animals. We haven't really gotten to the point of doing one under the Air Carrier Act language because it's still developing. But, and those two resources were actually just vetted and approved and posted within the past 30 days. So you can go there anytime and get that information. There are lots of academic resources, the Animal Legal and Historical Center from Michigan State University is probably one of the best ones that I've seen. Now, I'm going to touch on something that I don't have a PowerPoint form for, and it's related to just about everybody's legal practice. People who have emotional support animals and service animals, just like everybody else, die. And if you're doing legal work for an individual with an emotional support animal and or service animal, you might seriously talk to them about what's going to happen to the animal when you die. I bring this up because the gentleman that wrote the book Until Tuesday, the U.S. Army individual whose dog was named Tuesday, died here about 3 months ago, unexpectedly, suddenly. I have no idea what happened to Tuesday. But in the state of Nebraska, if you do a will, you can have a provision in the will that says, I dispose of certain property by list that may exist at the time I die. There are certain restrictions on what can be given by list. You can't give business properties. You can't give cash. But you can give personal property like a service animal or an emotional support animal. So if you've got a person that you're dealing with that has an emotional support animal or a service animal, talk to them about what happens when that animal dies. Or not when the animal dies, but when they die, right? Because if they die and the animal's still there, it's part of the family. Where does it go? And just about every attorney I know does a will every now and then. So it's something that you might want to consider when you're talking with a client that may have an emotional support animal or a service animal. Emotional support animals and service animals, you're going to see them all the time. There are more and more people as we age out who are going to be using service animals. More and more entities are making them available. Service animals, a well-trained service animal can be expensive, but you can train them yourself. Doesn't have to be $10,000, $15,000, but there are service animals that have been trained that can run that cost. Another reason to think about where does the animal go when you die. But as we baby boomers get older, and which includes me, we are likely to be using more and more emotional support and service animals. So it'll play a role, and it's likely to play a role more times than you'd expect it to. Any questions at all? I think I covered it with about 5 minutes to spare.
Actually, we're out of time.
Wonderful.